This right here is one of those courtroom moments that starts off confusing and then quickly spirals into absolute chaos. We've got a defendant who doesn't just want more time, he doesn't even want to acknowledge the basic rules of the courtroom. Instead of answering a simple question, his name, he immediately shifts into what sounds like a special appearance argument, something commonly seen in sovereign citizen-style defenses. Now, if you've watched cases like this before, you already know where this is heading. The court needs one thing to move forward: identity. But the defendant? He's about to challenge the very foundation of that process. And here's what makes this case so fascinating. The judge is calm, direct, and trying to keep things grounded in reality, while the defendant is operating in an entirely different legal universe. So the real question becomes, how long can this go on before the court steps in and shuts it down? And more importantly, does this strategy ever actually work?
Raymond of the family Paulo.
Excuse me, I told you not to interfere and you accepted that liability. As per FARA, Foreign Agent Registration Act, you do not have the right to represent me as a legal person because that would be a fraud upon the court.
Okay.
Per FARA,
Mr.
FARA,
Paulo or Ray or Raymond, how do you like me? How would you like me to refer to you, sir? I can't just say, hey, you. How would you like me to refer to you?
Capacity as an interested party.
Is that what your friends call you? Your family call you?
Non-resident alien to the U.S. and I'm not doing any business whatsoever and or trade into the jurisdiction of the U.S. and or subcorporation. I have never been in the United States. That's the facts. And so per the common law, trespass is now being attempted at this point in time. And from the beginning, I want to address this in a particular manner in order to settle these differences so that there is no unlawful conversions of estate property.
Okay, I'm going to jump over to the prosecutor and ask them what they know. So, okay, Mr. Sharp,
okay.
Has this person been identified?
Moment, please, Your Honor.
Okay, so is Mr. Sharp, do you have a first and last name?
One person at a time, sir. Let me hear from the prosecutor and then I'll turn back.
Yes, Your Honor. Mr. Paulo's identity was confirmed when he was trespassing and searched.
Slow down, sir. I just need to hear from one person at a time. I will come back to you. So please keep your peace while I listen to the prosecutor. All right. I'm sorry. Go ahead.
Your Honor, a search incident to arrest uncovered a Washington State ID card that confirmed his identity as Mr. Paulo.
Raymond Paulo with a date of birth June 25, 69?
That's correct.
Okay. All right. So,
a legal person or a dead entity or a corporation? So,
sir, are you telling me you don't want an attorney to represent you or what?
Attorney, in fact, I wouldn't need any to represent me, especially under the 11th Amendment. This would be an unlawful proceeding due to the facts.
Well, all right. So you got a right to have a lawyer represent you because you're charged with a criminal offense by the city of Lacey.
Rights.
And do you want Ms. Ganem, who's an attorney here in Washington, to assist you today?
Excuse me, I said I needed 10 minutes, and you were saying you're going to suggest something or another.
Well, I may give you 10 minutes, but we may see you tomorrow too. But I wonder, do you want an attorney to assist you?
Okay.
Do you want an attorney to assist you or not? I just need a yes or no there.
I'm hereby going to enter an order into the common law side of this court.
So I need a yes or no, sir. Do you want an attorney to assist you?
Exhaust my
a yes or no answer, sir. Do you want an attorney to assist you? Can you answer yes or no to that? Do you want an attorney? Do you want an attorney?
I am an attorney, in fact, for the unincorporated state, and with all due respect, the U.S. and all of your administrative law is not providing me any services due to the facts is that I'm ordering a stay on the common law side of this court in order to address my
own. So you say you're an attorney. In fact, have you been allowed to practice law in the state of Washington by the Supreme Court of Washington?
No, I'm not a bar member.
So you are, in fact, not an attorney.
I'm not okay. I'm a man.
All right. So do you want an attorney to help you?
I'm hereby entering an order on the common law side of this court in order to stay for these administrative hearings for me to exhaust all my administrative
You got a few, I think you're a little confused and you got bad information. This is a criminal case, not an administrative hearing. It's a criminal case. You're charged with a crime called criminal trespass in the first degree, and it carries a maximum sentence of 364 days in jail and a $5,000 fine. And again, you have a right to have an attorney and a right to not testify against yourself if you go to trial or hearing. You have a right to be presumed innocent, and you cannot be found guilty unless the city of Lacey proves this against you to beyond a reasonable doubt, or if you pled guilty to it, that would be your choice. Again, you have the right to have an attorney assist you here. Anything? I'm still trying to get a question answered there. Do you want to answer that question or not?
Am I going to be able to answer without your interference? Because you keep cutting me off. That's not the sort of conduct that's necessary. It seems to be you're practicing law from the bench. I would appreciate it if you refrained some stuff.
This is where the courtroom dynamic really starts to break down. The judge is asking one of the most basic questions possible: what is your name? And instead of a direct answer, the defendant is deflecting with philosophical and legal-sounding language. Now here's the key issue. Courts cannot function without identifying who is in front of them. It's not optional, it's foundational. And what you're seeing here is a classic clash between procedural law and personal belief systems. The defendant is trying to separate himself from the legal person, while the court is simply trying to establish jurisdiction over a real physical individual. That disconnect creates friction, and fast. So let me ask you this: should the court entertain these kinds of arguments, or is it right to shut them down immediately to keep proceedings on track?
Attorney, I'm the judge here.
Okay, well,
and we're trying to get through an arraignment, and I've told you what you're charged with and what the maximum possible sentence is.
I'm not a debtor.
You've gone through your rights, and some of those rights also are, if you were to go to motion or trial, you have the right to have the court order people to come testify on your behalf, and you have the right to question witnesses that may be brought by the city against you. So where we are is I'm still trying to figure out if you want an attorney, and you haven't asked me to appoint an attorney, but I can do that if you'd like.
So you're not able to basically act in accordance to the canons. So at this point in time, by special appearance and limited manner, I'm entering an order by special deposits to the foreign courts in order to put a stay on the hearings in order for me to exhaust my administrative remedies.
Okay. So
I hereby order the court to vacation any liens on the account and release the real property and personal property. I believe it's Standard Forms 1991 if they're still in effect.
Yeah. So, Ms. Ganem, anything you want to add here?
Nothing additional, Your Honor. I was not able to get much information.
No, I told you you're not to be happy.
One person at a time, Mr. Paulo, please. Let me just hear from Ms. Ganem, and then I'll turn back to you.
I Raymond of the family Paulo. Do not unlawfully convert the estate name.
All right.
Title is an unlawful conversion. This is identity theft.
It's not identity theft. It's the identity of an American state moron who thinks they...
And there it is, the moment where the argument completely collapses under its own weight. The defendant claims to be an attorney, in fact, but when the judge asks the only question that matters, are you licensed to practice law in this state? The answer is no, and legally that's game over for that claim. Being an attorney, in fact, in everyday language doesn't make you a courtroom attorney. It doesn't give you the right to practice law, represent others, or bypass court procedures. The judge handles this perfectly, calm, direct, and grounded in actual law. Meanwhile, the defendant doubles down, continuing to reject the system while still being subject to it. So here's the question. Do you think he truly believes this argument holds up? Or is this just a strategy gone completely wrong?
And then you respond. Stop interrupting. We're going to have to... Okay, I will come back to you. I will be coming back to you. So listen and then respond. So first off, we got to listen. So Mr. Sharp.
Thank you, Your Honor. Again, the city has grave reservations it would like to express about Mr. Paulo being allowed to represent himself. And while he may have a right to do so, The statements he's made before the court today seem to suggest he either has multiple grave misunderstandings about the way the law works and the way the court proceeds, or is just unwilling to participate in the process in a functional way. Either way, it seems a grave injustice to not have a properly educated and trained attorney assisting him. However, I do recognize that he has that right should he choose to exercise it. City's requesting $250 bail on this case, law-abiding behavior. Did he not have any contact with the Peak Credit Union? Your Honor, the street address for that is...
Is this in the United States?
Your Honor, that's 4-4s, 6th Avenue Southeast. Oh, excuse me, I'm sorry. I've got the wrong report for the address here. Pardon me.
You made a mistake.
4540. You know, that's 4540 6th Avenue Southeast. City's bail request is based on concerns over Mr. Paulo's ability or likelihood to reappear under Rule 3.2. The statements that he's made before the court today suggest that he's not likely to respond to the court's orders, given that he's rejected the court's authority over this matter. City believes without some bail, he would be likely to fly or at least fail to appear for future hearings.
To talk with Mr. Paulo, for lack of a better name that I can use here. And I'd like to, it's been difficult for us to talk, obviously, too.
On my common law side of the court, definitely, if you're going to unlawfully convert and it suggests that we're running in a different manner, well, then I'm not participating in bad faith. And with clean hands, I'm not participating in the unlawful conversions of the unincorporated as a state property.
So,
and that's
Ms.
land
Canna,
included.
Yes.
You called down, or how did you, were you on the phone, or was he not willing to talk with you? Or
I attempted to speak on the phone, and he has made it clear to me that he does not want me to speak on his behalf at all.
Stand down. You're in violation of FARA, Foreign Agent.
So nobody's in violation of anything here. I'm just asking questions, sir.
Yes, Your Honor. I attempted to have a conversation with him, and he has not answered any of my questions that I asked him, and has made it clear that he does not want me to say one word on his behalf at this hearing.
Okay. And so, yep, Mr. Sharp.
Given the statements made before the court here this afternoon, the city feels obligated to, well, I'll defer to the court on this, but would suggest considering the issue of competency. The statements have been consistently nonsensical and seem to suggest that Mr. Paulo may have an inability to understand the court proceedings. Without further information, we can't rule out that he's able to proceed competently. City would, again, defer to the court, but perhaps an evaluation is in order.
So I'm not convinced at this stage. I'm convinced that Mr. Paulo doesn't agree with the proceedings and doesn't agree with the state of the law in Washington, and that's fine. Problem is, it's still happening the way he doesn't agree. It still is a fact. And so, Mr. Paulo, I'm being asked to have you post bond or in order to be released, and then set another hearing and have you back to court if you are out of custody, or have another hearing anyway if you're in custody. Do you have anything to say about this request from the city, and also that you don't go back to that 4540 6th Avenue Southeast? It's a credit union, did you say?
It's the Peak Credit Union.
Peak Credit Union. So you have anything to say on that? I think somebody muted you, so we're going to need the help of corrections there and Lacey to unmute you.
Me?
You're back. So do you have any response to what the city wants me to do on release conditions?
This might be one of the most surreal moments in the entire hearing. The defendant is now trying to read the judge her rights. Think about that for a second. In a courtroom, authority flows in a very specific direction, and reversing that dynamic doesn't just confuse the process, it completely disrupts it. What we're seeing here is a breakdown in understanding of how legal roles actually work. The judge isn't just a participant, she's the authority presiding over the case. And yet the defendant is treating this like a one-on-one legal standoff where both sides have equal procedural power. That's not how it works. And moments like this often signal to the court that the defendant may not be engaging in good faith. So ask yourself, at what point does the court stop entertaining this and start taking stricter action?
To you.
A man?
You're a physical human being in the Nisqually jail. I'm talking to you.
A man, yes or no? Are you speaking to a man?
You look like a man to me.
Okay, well, I know what I look like, but I've asked you directly. Are you directing me to that question as a man? Not that I look like one, because I'm a man, I'm not a legal person, and I'm not a corporation.
Okay, to you, the man who's sitting in Nisqually jail.
Okay, and so
what do you say?
Is that identified as a legal person then?
What do you say?
I'm sorry, you're cutting out.
What would you like to tell me about what I should do about your custody status? Should I let you out? Should I not? Should I order you to stay away from Peak Credit Union? What do you have to say about that?
Well, I would like to request the judge's chambers in order to protect my privacy.
No, this is a public hearing. We're going to do this in public.
Like
so what's your response?
I believe it's called Star Chambers in order to protect my publicity. And
so do you have a response to that question about release conditions or not?
Okay, I'm sorry. This is very echoey in here. So if you keep cutting me off, you're frustrating me for no reason other than it fears you're interfering. So if you could just respond slower and not cut me off because you're agitating me. As an American with disabilities, and I've been deprived for now 8 days of a hearing. So beyond the 48 hours, I don't know why we're even listening to this, because you failed to meet the mandatory obligations to bring any party to the courts. So
Mr. Paulo, what we're doing here is I'm entering a plea of not guilty to this allegation of criminal trespass in the first degree. I'm not appointing an attorney, as you've told me that you want no one to help you. You can change your mind about that, and we can appoint an attorney, and keep that in mind. I'm going to order that you don't go back to that Peak Credit Union where this is alleged to have occurred at 4540 6th Avenue Southeast in Lacey. Don't go back there, and don't violate the law otherwise. I don't see a history of failing to appear in court for the last 20-some years, so I'm not going to have you post any bond, but I'm going to give you a court date to be back, and you're representing yourself unless you ask the court to appoint somebody or we think differently about that. But you've got to tell us if you want an attorney appointed. And what date?
Okay, the issue at hand that I hear is that you're saying representing myself. I am myself as an attorney in fact. So the fact of the matter is if you misrepresent and misidentify the things I'm stating.
And just like that, this courtroom saga comes to an end, but not without leaving behind some serious takeaways. The judge allowed the process to continue despite constant interruptions, unusual legal claims, and outright rejection of the court's authority. Yet in the end, the ruling stayed grounded in reality. A not guilty plea entered, release granted without bond, and clear conditions set moving forward. What's fascinating here is the contradiction. The defendant rejects the court's authority at every turn, but still benefits from its decisions. That's the irony at the heart of cases like this. From a legal standpoint, this case highlights the limits of so-called sovereign citizen arguments. They don't override criminal law, and they don't stop proceedings. Instead, they often complicate things further for the person making them. So now we turn it over to you. Was the judge too patient, or did she handle this exactly right? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.